Welcome to welcome to our webcast today. First of all, thank you so much for registering. I know today's a cold day, and obviously some of you might be giving up your lunch hour to join us. And I hope you're armed with a hot soup and a sandwich or lunch while you listen to our website. So my name is Joanne Yi, and I'm a partner with EY International Tax and Transaction Services based in Hong Kong. I also lead the APAC tax technology sector. With me today, two honorable guests, Karina Tay, a partner of LC Lawyers LLP from the Dispute Resolution and Compliance and Investigations team, and Catherine Wong, an associate from her team. They represent clients in governance, regulatory, and compliance matters and commercial disputes. So Karina and I actually are also the Maychem Professional Services Subcommittee. And so we're very honored today to have the opportunity to give you a presentation on the topic, Be Prepared, Understanding Your Duties as Professionals, Directors, and Senior Management. I am hearing a bit of an echo. Sorry, I just want to make sure. Yeah, okay, sorry. Um, so as many of you won't be surprised to know, hence I guess the number of attendants from very senior management teams attending today based on your profiles of your registration, there has been significant increasing enforcement actions and proceedings taken against individuals in respect of their contravention of laws and regulations, but also for contraventions by the organizations they work or represent. Now, the sanctions for non-compliance can be severe, so including loss of reputation, loss of license, disqualification, disbarment from practice, pecuniary fines, and possibly even imprisonment. So in view of the above, knowing and complying with the contractual duties related to compliance matters, such as confidentiality or competence, and legal duties across sections such as competition and AML laws, as well as regulatory duties arising from specific regulated industries are essential. Obviously, professionals who have fiduciary roles, such as directors and trustees, should also know and comply with their fiduciary duties and take extra care when potential conflicts of duties and interests arise. So today, Karina and Catherine, as legal practitioners, will provide you an overview and enforcement actions against individuals, talk about the duties and liabilities of professional directors and senior management, and discuss details to note when dealing with regulatory authorities. Now I'll pass the time to Karina and Catherine for today's sharing. Thank you so much.
Thanks, Joanne, for that introduction, and thank you everybody for joining us today in our webcast. Um, as all professionals, we have duties and responsibilities for the roles that we play, and increasingly, um, one of the key challenges for us as professionals is the ever-changing, fast-paced regulatory and legal developments. And on top of that, we are all being asked to do more with less. So it becomes quite critical that we really understand our duties, our responsibilities, and are able to mitigate risks as they arise. Otherwise, as Joanne has said, we may find ourselves in a very difficult situation, not only because of our roles, but also because of what people we supervise may either inadvertently and or advertently uh, do. So, one of the other things I think I'd like to mention, and we will cover, is that in Hong Kong, we are seeing more and more regulatory bodies getting quite wide and intrusive powers of investigation, which um, require us to provide information and to participate in investigations where our rights against self-incrimination are actually abrogated. So these are also things that we really do need to take into account when we go about our jobs as professionals. So without further ado, let me turn to our discussion on um, some enforcement cases that I'd like to take you through very quickly to demonstrate to you is essentially the cases that are being taken against individuals because of what they do and also because of their organizations and in their roles as professionals. So moving to the next slide, we have the first case really is an insurance case where a former insurance agent was basically reprimanded and prohibited from applying for a license. Now, for various breaches of the professional code. And essentially, what he had done was, in fact, contravened the company's internal policies on cross-border selling practices and and also with policies and procedures and requirements in appointing insurers in carrying out regulated activities. So essentially, it was found that he was had undertaken some regulated activities likely to prejudice the interests of the public. So this was a situation where he basically got debarred from applying for a license for 5 months. The next case relates to an SFC related matter where a former relationship manager and former executive execution dealer was also banned from re entering the industry for life following convictions on uh, against the Prevention of Bribery Act. So essentially, some corrupt practices that he was involved in ended up in his debarment essentially for um, because he was found not to be fit and proper person to be regulated, and also for providing false and misleading information to the SFC. The next example is cross moving on to the monetary authority, where again a person who was an associate director and a team head of a priority banking um, was also suspended um, and found not to be fit and proper because of acts of dishonesty. And in this instance, it was an interesting one because the person involved really had got into trouble because she had filled in the wrong form, and instead of getting the customer to come in again and sign a new form, basically copied the signature and put it onto the correct form, and then tried to pass that off as the instructions from the client. So really not really gaining something from her conduct, but actually engaging in conduct which was totally inappropriate, um, because you know, for expedience reasons. The next case is one where four individuals, and two of them former executive directors, and essentially were with a placing agent, and they were found guilty for a conspiracy to defraud and ended up serving jail terms. And two of the directors were disqualified. Next case. Now we move to the competition arena, where there are two different cases that we've highlighted. One where there were contractors who were engaged in anti-competitive behavior, and essentially they were there were pecuniary penalties against each of them, and the director again was disqualified for 22 months. And there's another case involving also an anti-competitive behavior where partners in the firm who were not actually involved in the conduct itself, but because of by virtue of their roles as partners in the firm, were essentially were held responsible and had to it, had the pecuniary penalties enforced against them. So moving on to the next case. This is an SFC case where a former licensed representative was suspended for 2 years for, again, failing to act honestly with due care, skill, and diligence, and failing to inform the SFC relating to other competing businesses that he had. Um, and finally, again, another SFC related case where a former manager and senior manager of two banks were banned from re entering the industry and following an investigation by the SFC. So essentially, what this illustrates is that all of these are individuals, in professional individuals within different arenas. So you have the HKMA, some banking. You also have regulated activities regulated by the SFC, the Insurance Authority,
And then, of course, just in terms of businesses in general, the Competition Commission. So and some of these cases are due to dishonesty, but some of them were not. And then also we have, as Joanne had highlighted initially, the repercussions are severe. You have people being in prison, you have people having to bear large fines, and then most importantly, you also have reputational impact and basically debarment or suspension from their ability to perform their duties and essentially their livelihood. Now I'm going to hand over to Catherine, who will take you through some of the statistics so that you can see that these are not one-off situations.
Thanks, Karina. So as Karina has mentioned, enforcement actions have been enforced against both regulated as well as non-regulated sectors in respect of breach of the relevant laws and regulation. Proceedings have been brought and different types of sanctions have been imposed against these individuals, including fines. So here we set out some enforcement statistics for your reference. Taking the HKEX as an example, for the 6 months ended 30th June 2021, a total of 135 cases have been handled and 22 disciplinary actions have been concluded. Sanctions have been imposed on individuals as shown on the slide, with a comparison with the figures in the corresponding periods of 2019 and 2020 on the left. You see that more individuals have been sanctioned against over the years. As to the nature of the enforcement themes, individuals have been sanctioned as a result of a breach of director's duties, failure to cooperate with an exchange investigation, inaccurate, incomplete, and/or misleading disclosure in corporate communication, failure to comply with procedural requirements in respect of notifiable or connected transactions, repeated breaches of listing rules, and the financial reporting delays and internal controls and corporate governance issues. For the SFC for the quarter ended 30 June 2021, a total of 435 investigations have been carried out in relation to corporate misgovernance, insider dealing, intermediary misconduct, market manipulation, and unlicensed activities. The majority of the investigations relates to intermediary misconduct. For the quarter ended 30 June 2021, a total of 253 persons or corporations have been subject to enforcement action, and we have provided a breakdown by the types of enforcement actions taken on this slide, the majority of the actions being disciplinary proceedings. You will see that in 2020 and 2021, civil proceedings brought by SFC remains very high. Moving on to general duties of professionals. As professionals, regardless of which sector we belong to, we will be subject to general obligations such as duty of confidentiality, duty to discharge your professional duties with integrity and fairness, and duty to act competently and to exercise care, skill, and diligence when discharging your duties. It is important for us to safeguard confidential information relating to clients and not disclose such information to other parties without prior written consent. It is also important that we discharge professional duties with integrity and fairness, observing the standard of personal integrity required in the relevant field. It is also essential that we are competent enough to provide adequate level of services and give opinions in our professional capacity in the relevant practice. Therefore, it would be beneficial if we as professionals would take steps to maintain adequate development of our professional competence. Apart from general duties, which we would normally find in our industry's code of conducts or employee handbooks, we will also be subject to statutory duties, such as not being involved in anti-competitive behavior, money laundering, bribery, or fraudulent behavior. To do so will result in an offense that is punishable by fines and imprisonment. For competition in Hong Kong, anti-competitive conduct is prescribed by the Competition Ordinance and regulated by the Competition Commission. So extra care should be taken when attending meetings, especially industry group meetings. We should always make sure that meetings are for legitimate purposes. For example, that we will discuss issues of interest to the industry as a whole. We should be vigilant about what is discussed, object to attempts to raise or agree any anti-competitive strategies, arrangements, activities, and or conduct, and leave any meeting immediately if the discussion continues after objection is made. We should also take, agree, and keep minutes of any meetings and seek legal advice in case of doubt as to whether any matters discussed or information to be exchanged may be competitively sensitive. As a general rule, we should not make statements or agreements that could be interpreted as an invitation to coordinate behavior, involve cartel conduct, involve collective action, and or relate to future plans on scope of products and terms of supplying new products or services. Moving on to anti-money laundering. In Hong Kong, the Organized Crime and Triad Bureau investigates complex organized crime and serious triad offenses. JFIU is a joint task force of customs and the police, and they work hand in hand with OCTB to receive and handle reports about suspicious financial activities. We may find ourselves unwittingly called up by the ICAC and or Hong Kong police with regard to potential contraventions involving bribery, commercial crime, or money laundering. This reiterates the essentiality to cautiously conduct KYC checks and CDD on all counterparts. So here are some tips on guarding against exposure to money laundering risks. Firstly, we should ensure that we know the identity of the counterpart, including obtaining the HKID or passport in respect of an individual, or the articles in respect of a business, as well as information on its beneficial owner, and that our counterpart is not participating in illegal activities and not using a transaction to hide proceeds of crime. We should also always conduct CDD and obtain information on the nature and intended purpose of the transaction to make sure that it is a bona fide transaction for a legitimate purpose, the business relationship between the counterparts, and the source of funding. There should be ongoing monitoring of the business relationship. Notably, in the event that there are signs of suspicious activities or parties, for example, complex or unusual transactions, high-risk clients, more vigilant due diligence should be conducted, including making further inquiries or investigations. Suspicious transaction reports should also be filed with JFIU if there is knowledge or suspicion that any property may be proceeds of or was used in connection with or is intended to be used in drug trafficking or an indictable offense, as failure to do so is an offense. However, we are aware that there have been situations where legitimate business got mixed up in the money laundering process through the transfer of illegitimate money. To avoid these incidents, we advise that we consider putting money in escrow and earmarking the specific use of the sum. We'll elaborate on this with a case study later on in the presentation. Lastly, the POBO, Hong Kong's main anti-corruption law, regulates both the public and private sectors. It prescribes the soliciting, accepting, or offering of an advantage, which is widely defined in Section 2 of the POBO as covering a wide scope of benefits. Corruption thrives in difficult economic times, particularly when organizational and enforcement oversight is weak. We highly recommend that professionals should remain vigilant. We must not offer an agent or employee or public servant any advantage to act or forbear from acting in relation to their principal's business. An agent or employee or public must also not solicit or accept any advantage without lawful authority or reasonable excuse for acting or forbearing to act in relation to the principal's business. So as professionals, we should keep close to our employees, warn them of heightened corruption risk, and continue to remind them of the need to adhere to ethical standards and be compliant with law, regulation, and internal policies, procedures, and controls. Karina will go through a case study with all of you regarding competition law, and then as well as money laundering case study. Yeah.
Thanks, Catherine. We thought it'd be best illustrate some of the points that Catherine had been making with some case studies, which I hope you'll find interesting. The first one we're going to deal with relates to an anti-competitive enforcement case. And it's the case that I mentioned earlier on regarding the partners who got essentially into trouble because they hadn't really
been vigilant about what the other partners were doing. So in this particular case, 10 contractors had participated in a market sharing and price fixing arrangement in relation to decoration work in a public housing estate. And for some unknown reasons, the action was brought against only two of the partners trading as the firm Tidal, and not against the firm nor all four partners of the firm. And the named partners had not been involved in and did not have knowledge of the anti-competitive conduct. And after the enforcement action was completed, the tribunal imposed a pecuniary penalty on the named partners to the tune of 420,000, which was upheld on appeal. The two partners involved appealed to the Court of Appeal but were unsuccessful. And the reasons that the Court of Appeal gave were essentially a restatement of the law on partnership. Essentially, regardless of whether you're a silent partner or a junior partner or even a salaried partner, you have the same level of liability as any of the other partner of the firm for partnership acts. So essentially, um, our takeaway for this particular case is that you do need to choose your fellow partners carefully, and you do need to exercise oversight over their conduct. Because if you don't, you are jointly and severally liable for what they do, and irrespective, as we mentioned, of your role in the partnership. So this is the takeaway. And we move now to the next case study, which we're dealing with in terms of money laundering. As you know, there are very, very strict laws on money laundering that require us to know who our clients are and to ensure that we don't get embroiled in their acts of money laundering. So essentially, let's have a look at the facts in this case. It's a sad case of a solicitor who a senior partner in a firm, and he had essentially worked to help a client, a well-known and uh, client that he had a long relationship with. He'd been basically helping this client since 2005 on listing matters. And 5 years later, the client, JC, asked him to act in relation to a particular transaction where an investor was wanting to buy the majority interest in his wife's enterprise called Dragon Joy Limited. And during that meeting with the solicitor, JC gave him a check for $68.9 million, very, very large sum of money, of course. And D1 told JC that he could not act for him because there was a potential conflict of interest, he having previously been involved in a deal regarding Dragon Joy. But JC said to him, "Can you please do me a favor because it's urgent?" And the investor W really wanted to make sure that everything was legitimate, and they wanted the assurance that everything was done properly and through a solicitor's law firm. So essentially, what happened was that he persuaded the solicitor to allow the check to be deposited into the client account of the firm, and then made arrangements for the check to be subsequently another check to be issued the following day to his wife. And so that's what the solicitor did. And in the next day, the check was written out of the client account and payment made to the wife. And the voucher basically described the payment as being made to the wife for costs and disbursements refunded to the client. Now, both the solicitor and the wife were charged with, the client's wife were charged with money laundering. And the solicitor, who we're focusing on in this case, was initially convicted and sentenced to 6 years imprisonment. And you can just imagine the reputational impact for the individual involved. But fortunately, following an appeal to the Court of Appeal, where a point of law in terms of the standard of proof was clarified, and following a subsequent retrial, the court hearing the retrial, gave him the benefit of the doubt and acquitted him. So, in terms of the rulings that at the first hearing, let me take you through what I think are some important aspects that we all need to watch out for, because these are the little things that could potentially get us into trouble. So, in the first hearing, the court did not believe the solicitor in his testimony and took into account that, firstly, he knew that his client had, amongst other things, in 2004, been adjudged by the CSRC in mainland China to have been involved in fraudulent account tax statements, prohibited from holding positions in listed companies and securities businesses for 3 years, and in 2009 had been forced to resign his position as a CEO and joint chairman and executive director of a listed company here in Hong Kong by the HKEX. Um, and the complaints were about his integrity. The second point that was taken into account was that the amount was unusually large, particularly for a preliminary deposit, and when the transaction details had not actually been agreed. Thirdly, JC's instructions were unusual, as the money was destined to go from his company's bank account to his wife's bank account the following day, all washed through the solicitor's client account. And finally, practice direction P, which is basically a code of practice or guidance for the law society members for all solicitors. We are required under the practice direction to ensure that we carry out client due diligence and essentially to make inquiries when there are issues in terms of the nature and intended transaction and also the source of funding, none of which the solicitor in this case took heed of, and essentially he was in breach of the code of practice himself. Now, the breach itself was found or held not to be essentially evidence necessarily per se of a crime, but it really raises commensurate concerns and serious issues. So that was the grounds on which he was convicted in the first instance. Following the retrial, the ruling, and as I mentioned before, the court gave him the benefit of the doubt and acquitted him, taking into account that he did not instruct his secretary to take steps to conceal the fact that the funds had flowed through, firstly, from JC's company to his wife's bank account. He had not really taken any steps to ensure that he was in control of the issuing of the check, and there was no evidence that he actually gained anything in helping JC with this transaction, and essentially was naive in doing a favor for a long-term client who he trusted, whether mistakenly or not. And the fact that while he had breached the practice direction P, it was not clear whether he had that in mind when he was undertaking these steps to help his client, and could have been because he was ignorant or careless. So essentially, the key takeaways from this is that as all professionals, we do need to take care in respect of all the transactions that we undertake and the clients we work for, and conducting KYC and CDD, making inquiries when we really have red flags will help us firstly identify the red flags, of course, and then whether or not to carry on, take them on as a client, take on the matter, and carry out the instructions that we are given. Essentially, because the repercussions and are dire. Um, so on that, I'll finish on money laundering and then move on to the next case study, which is really another very interesting case, and in my my view, quite a scary case for professionals acting um, for clients. This is a case in terms of it was really someone who was giving violin lessons actually. So the defendant had been engaged by a parent to give violin lessons to her son, and she had been teaching him really from since 2009. And in 2013, the mother asked the teacher for recommendations in buying a new violin. and she did help her. She found the made calls to uh, in, music instrument shop that she knew, got them to reserve the violin, helped, took the mother down with the son to try out the violins, and then negotiated the price. And what happened subsequently is that the mother bought the violin for the son, and with the reduction in price. But subsequently, the teacher got a basically a commission from the instrument shop and received 20,000 in terms of the commission, which the court subsequently found was about 7.5 months of uh, uh, the teaching fee, monthly teaching fee. So she was initially charged with the Section 9 of the Prevention of Bribery Ordinance, which is really a corrupt act of an agent. And initially, the magistrate's court had found that she had no case to answer because she was not an agent. Let's have a look at the prosecution's. The prosecution brought a appeal by way of case stated, seeking clarification of the definition of what is an agent. So let's have a look at the rulings. So just to recap before I go into the rulings. So you have a situation where the teacher was really teaching, the pre-existing contract was really to teach. And it was found by the first instance, the magistrate, is that the extra efforts that she took to find the violin, introduce and negotiate the price, etc., is separate and distinct from the pre-existing contract to teach to play violin. But in the Court of Final Appeals decision on this question of law, which is something that we all need to take heed of, when is one really can be found to be an agent? And it is simply this: so long as you agree or choose to act in circumstances where you give rise to a reasonable expectation to act honestly and in the interest of the person that has either requested you or you voluntarily decided to do so, then you are really an agent, and you have a duty to carry out and act honestly and in the interest of that person and not put your interest in conflict with that. So bearing in mind this particular uh, clarification, essentially anytime we doing an act which is related to and can be seen to be uh, part of either the activity and or um, that we have taken on the responsibility for. We, we, we are required to disclose a situation where our interest conflicts with that of our client, and to seek permission if we are going to obtain any particular payment or commission. So essentially, this is something that may take some people by surprise, but this is the extent and the scope of the duty. So on that note, I'm going to pass back on to Catherine, who will take us through more specific duties.
Directors are all subject to directors' duties, and for directors of listed companies especially, we have more specific directors' duties. So the top two pictures on the left, they are the statutory duties of directors. Directors must exercise reasonable care, skill, and diligence, meaning the care, skill, and diligence that would be exercised by a reasonably diligent person with the general knowledge, skill, and experience that they may reasonably be expected of a person carrying out the functions in relation to the company, and the general knowledge, skill, and experience that the director has. Directors also have duty to keep accounting records, which means that they must keep the records in accordance with the company's ordinance and must preserve the records for 7 years after the end of that financial year. A director of a company who fails to take all reasonable steps to secure compliance commits an offense and is liable to a fine of $300,000. Directors also have common law fiduciary duties, which are the three yellow in the bottom, which includes duty to act in good faith in the interest of the company, duty to exercise powers for proper purpose, duty to avoid conflicts between personal interests and interests of company, and duty not to make secret profits. It will not make any difference that the profit is one which the company could not itself have made, or that there was no actual loss to the company, as long as the opportunity came about by virtue of the position as director. General principles of directors' duties are also summarized under the company's registry's guide on directors' duties. Directors should in particular bear in mind duties related to conflicts of interest, including duty not to enter into transactions in which directors have an interest, except in compliance with requirements of the law. For example, that they must not authorize, procure, or permit the company to enter into a transaction in which they have a material interest, and must not enter into a transaction with a company unless nature and extent of interest has been disclosed. For directors of listcos only, there is duty to answer to the company for the application or misapplication of its assets. Relatedly, we would like to highlight that for INEDs, although they have limited information as compared to executive directors, they are also subject to directors' duties and can be subject to same penalties. For instance, in 2021 in May, the Market Misconduct Tribunal ordered former and current directors to pay the SFC's investigation and legal costs and the MMT proceedings, and to attend an SFC-approved training program on the corporate disclosure regime, directors' duties, and corporate governance for their negligent conduct resulting in the company's failure to disclose inside information as soon as reasonably practicable. Specifically, on 27th April 2020, the SFC had found that a former non-executive director and 3 former INEDs were in breach of their fiduciary duties to the company by firstly allowing a former chairman and an executive director to exercise own discretion in controlling the affairs of the company and the board for personal advantage or other ulterior purposes, and secondly, having no effective system of internal controls in place to prevent the above from occurring. They were disqualified from being a director or being involved in the management of any listed or unlisted corporation in Hong Kong without leave of the court for a period between 2 to 5 years. Karina will go through a case study with you all later. The court in that case noted that executive directors and non-executive directors have the same responsibility in law as to the management of a company's business. We'll first talk about the conflicts of duties and interests before the case study. So generally, there are 2 types of conflicts of duties and conflicts of interest. Firstly, conflicts of duties arise when a person is required to fulfill 2 or more roles that may be in conflict with each other. Examples include where a duty may be owed to multiple clients, especially prominent in the provision of services, and where a chairman of a company also serves as a CEO, which has often been justified that the combined role will provide consistent leadership by someone who knows the company most well. Taking a specific example in the legal sector, in the solicitor's guide, a solicitor has the duty of loyalty to his client and must act in the best interest of the client, which may conflict with the duty of confidentiality owed to another client or a former client, where acting in the best interest of the client may require him or her to disclose confidential information or knowledge held in relation to the other client. Under such circumstances, as the solicitor has legal duty to avoid conflict, he or she must not accept instructions to act. Therefore, one should be aware of what duties are being owed to and to whom, and whether there may be any potential conflict of duties that will arise to take up another additional role. If so, it is advisable not to do so. On the other hand, conflicts of interest arise when a person's own private interest conflicts with that of the company's. For instance, where the company enters into a transaction with another entity in which a staff or director has financial interest who plays a part in making the decision to enter into such transaction, this gives rise to a situation of conflicts of interest. Other examples may include a bank staff approving applications for loans submitted by his or her family or relatives, or where an employee starts engaging in private dealings with clients. Prior to entering into a transaction, there should be sufficient scrutiny as to whether one's personal interest may lead to a conflict of interest upon the company transacting with a third party. It is important to manage potential issues upfront and discuss with your senior employer as early as possible once a potential conflict is detected. Issues of conflicts of interest can fall under different regulatory regimes, and we've found some case studies or examples for you to better understand different situations of conflicts. Firstly, failure to disclose conflicts of interest resulting in financial gains may be the subject of a corruption or bribery complaint, which is investigated by the ICAC. Recently, in November 2021, a former project manager of a sister company of a power supplier was sentenced at the magistrate court to 4 months imprisonment, suspended for 2 years for failing to declare conflicts of interest after having accepted loans totaling $135,000 from a contractor under his supervision, and guilty of using a document with intent to deceive his principal contrary to POBO. A second example will be that where an individual entity is under a regulated sector and the regulatory authority may step in and take sanctions. In March 2021, an industrial coating company, which is now delisted, and its subsidiary granted 2 loans up to 3 million and renminbi 7.5 million respectively to parties connected to 2 executive directors at a time in 2018, which constituted connected transactions, but have not been disclosed. The company and the 2 directors were censored by the HKEX for breaches of listing rules requirements to avoid actual and potential conflicts of interest and duties, disclosing fully and fairly interest in contracts with a listed company. Other directors, including INEDs at the time, as well as former executive directors and INEDs, were also censored for breaching the listing rule duty to apply such degree of skill, care, and diligence by failing to review the relevant documentation before approving the loans, to identify the conflicts of interest, and take steps to remedy such breaches. Similarly, the SFC also commenced proceedings in the CFI following its investigation into acquisitions by the subsidiary of a company that manufactures exterior automobile body parts. Its 4 executive directors were found to be in breach of their fiduciary duties and common law duties to exercise due and reasonable skill, care, and diligence in the course of acting as directors of the company. From the above case studies, we can see that it is essential to be able to identify potential conflicts of interest and respond as soon as possible by communicating with the company upfront. Moving on to disclosure obligations. Under the company's ordinance, if director of a company is in any way directly or indirectly interested in a transaction, arrangement or contract or proposed transaction, arrangement or contract with a company that is significant in relation to company's business and the director's interest is material, he must declare the nature and extent of his interest to other directors. The same duty applies to shadow director. Contravention is an offense liable to a level 6 fine, which is $100,000. There is also mandatory disclosure of interests under Part 15 of the SFO, which applies to any substantial shareholder of a listco. Individuals who have interest in 5% or more of any class of voting shares in a listed company, including associated companies, must make disclosure. There are also mandatory disclosure requirements on directors and chief executives of listed issuers of their interests and short positions in either shares or debentures of the listed issuer. Lastly, according to the company's disclosure of information about benefits of directors regulation, information must be contained in notes to financial statements about loans, quasi-loans, and other dealings in favor of directors, controlled bodies corporate, and connected entities. Next, Karina will go through the case study regarding executive directors and non-executive directors having the same responsibility in law as to the management of a company's business.
Thanks, Catherine. Before I go to the case study, I just want to make two clarifications in relation to conflicts. One, when we talked about conflicts of duties, there's another situation where we could get into an issue with conflicts, and that's when you have JVs and also when you have a PP investment into other companies, or which is usual. And quite often we parachute one of our people into the joint venture entity and or the investment company that we have. And essentially that director, that person who takes on the director role in the investment company or the JV entity really has two roles. One, he's the director of the investment company or the JV company, but at the same time, he owes his responsibilities to us, who basically parachuted him in there. So essentially, he's in a perfect example of a situation where he has two duties that I sometimes will get into a conflict situation. Quite often, we essentially have to deal with that by way of our shareholders agreement, which deals with these sorts of issues, and essentially where it's provisions are set in place in terms of what information that he or she may receive and may share with essentially us, who he or she owes a duty to. So that's the first point. The second point is in relation to shadow directors. Um, in case we are not everybody is aware what a shadow director is. A shadow director doesn't is a person who doesn't really have the official role in a company as a director, but is in the role of like the the individual who makes and calls the shots, and directors really follow his or her instructions in terms of the management and oversight of a company. So with that, let me move to the case study number 4, which looks at directors' duties and breach of duties. So looking at the facts, Catherine has, I think, highlighted some of provided an overview of the facts. In this instance, the person involved, a chairman and executive director of a listed company, had really essentially had control of the listco and its subsidiaries. And what happened was that one of the subsidiaries had entered into a transaction which had an acquisition which had profit guarantees uh, to the listco. And what he did, for reasons unknown, essentially, had obtained gave confirmation letters to the seller when the profit margin wasn't reached, and the confirmation letters allowed the seller to basically defer payment under the profit guarantees that had been given to the listco. And he also procured subsidiaries of the company to guarantee his personal loans. So the SSC commenced proceedings not only against him, but all 12 other directors of the LISCO, including non-executive directors as well as independent non-executive directors, seeking disqualification. And in fact, 7 out of the 13 former directors had been disqualified from a period ranging between 30 months to 5 years. So let's have a look at the rulings. And just to recap what Catherine has said, um, essentially the it was found that there was no objective, rational, or commercial reason for signing the confirmation letters, allowing the deferment of the profit guarantee. Secondly, there was also no objective and rational or commercial reason for the subsidiaries to guarantee the chairman's own personal liabilities. Essentially, the chairman was putting his personal interests above that of the company and the subsidiaries. And there was also an issue of financial difficulties of the enterprise. It was found in relation to all the directors that they had, firstly, with the chairman, he was able to control and dominate the affairs of the company and the board to his personal advantage. And there was no effective system of internal controls in the company. and the directors had essentially allowed him to exercise his dominion and control and neglected and omitted their exercise of their duties. In relation to both the executive and non-executive, it was held that they held the same responsibilities in law for the management of the company. And essentially, they are, while they may delegate responsibility amongst themselves, it still requires exercise of uh, independence and diligence in relation to ensuring that decisions are made in the best interest of the company. And further, they were held also negligent in terms of making false and misleading statements to the stock exchange because they had not really made the necessary inquiries, etc., before confirming the information that was given to the Hong Kong Stock Exchange. So the key takeaways from all this is that executive directors and non-executive directors do need to take care. When you take a position on the board, you're just as responsible for the executive directors, and ultimately you will be held responsible if uh, action is taken that is really not in the interest of the company. So with that, I'm going to pass back to Catherine to deal with the next segment, which is some specific duties in the regulated sectors.
So if you or in your company are in the regulated sectors such as the SFC or Insurance Authority or the HKMA, you will be subject to different regulatory regimes as applicable. It is important to understand the duties you have under the rules and regulations of the specific regulatory authority. Taking Section 193 to SFO as an example, if a licensed corporation is guilty of misconduct as a result of the commission of any conduct occurring with the consent or connivance of or attributable to any neglect on the part of a person involved in the management, that person is also guilty of misconduct. According to a Cambridge Dictionary, senior management refers to managers at the highest level of a company or organization. This would include CEOs, CFOs, chairmen, presidents, and board of directors of companies. You'll see on the slide the liability under the SFO of senior management. There's a recent enforcement action by the SFC in November 2021 that after sanctioning a licensed corporation, the SFC took action against a manager in charge, head of the overall management oversight key business line, who was also the firm's RO director and deputy general manager, and suspended his license for 6 months for failing to discharge his duties as a member of the firm's senior management. So senior management should be aware that they should be in charge of overseeing the business of a company and have the responsibility of implementing and maintaining appropriate systems and procedures by the company. Apart from the SFO, the listing rules have also been recently amended in relation to disciplinary powers and sanctions, and the amendments came into effect on 3rd of July 2021, and they're shown on the slide. Overall, this shows that a wide scope of individuals may be exposed to the disciplinary regime by the HKEX, even though they may not be directly regulated by HKEX per se, but for their roles in the management of listed issuer. Karina will move on to talk about the investigation powers of regulatory authorities in Hong Kong and how we should deal with regulatory authorities.
Thanks, Catherine. I think those of us in the regulated sector, regulated by the SFC anyway, will be familiar with the investigative powers, which are broad and intrusive. Essentially, the investigation powers include the ability to obtain documents and information, require answers, whether orally in an interview and or through statutory declarations, and essentially then providing the information that will feed into the investigation process. Now, what has ha basically happened over the last few years is that the similar types of powers have actually been expanded now beyond the regulated sector to include, say, for example, the Competition Commission will have similar powers. And most recently, the Privacy Commissioner, under the new amendments to the PDPO that came into force, now also have very similar powers. So what are the key things that we need to know about these powers? Moving to the next slide. So essentially, one, when there's an investigation, we are all required, if we're in receipt of these notices, to keep the content of the investigation secret. And it would be an offense, which is punishable by a fine as well as imprisonment if we discuss any of the content of the investigations. Secondly, there's an obligation to cooperate and provide truthful materials and information. Failing to do so is also an offense, which is punishable by a fine and imprisonment. Now, why is this second piece important? It basically abrogates our common law right to absolute silence. So you can imagine that when if you ever get caught up and you're being asked questions by the police, you can say, I am exercising my right of silence. I'm not telling you anything. But with regulatory investigations of this nature, you are not allowed to exercise that right of silence. You have to provide that information, come what may, even if it may incriminate you in whatever way. So essentially, and if you fail to do so, basically you're found to be non-cooperative, and essentially you are able to be prosecuted for being um, by a fine and or imprisonment. So the consequence of that is that you do have to be very, very well prepared if you're going to turn up for one of these investigations and provide information, even though you may not be a person under investigation. The key thing to remember is that you have a right to confidential legal advice, and you have the right to exercise that right by over privileged information or advice that your lawyer gives you. And the key point to make in these interviews is that if you claim the right against self-incrimination, the information cannot be used against you for criminal prosecution, except if you give misleading information. But it can still be used against you for disciplinary and or administrative related proceedings. So one of the key things to remember for these sorts of issues, and you remember now it's not only regulated industry, Competition Commission and the Privacy Commissioner has very similar powers. So the key thing is you do need to be prepared if in any circumstance you unfortunately are asked to answer these sorts of questions in an investigation by some regulatory authorities. Now, on that note, I'm going to pass on to Catherine to provide you with our thoughts in terms of concluding remarks.
So in conclusion, there have been increasing enforcement actions or proceedings taken against individuals in respects of their own contraventions of laws and regulations, as well as for contraventions by the organizations they work for. And the sanctions for non-compliance can be severe and include loss of reputation, loss of license, disqualification, debarment from practice, pecuniary fines, and imprisonment. And other point we want to emphasize is that knowing and complying with contractual duties in relation to confidentiality, competence, etc., legal obligations that are applicable across sectors such as competition, money laundering, bribery issues, as well as the duties owed by professionals under regulated industry is key. Also, we understand that a lot of our audience today, being professionals, may be asked to take on fiduciary roles, such as directors and trustees. If this is the case, we should be aware of and comply with the fiduciary duties, such as the scope of directors' duties and the extent to which you may be held liable for the company's actions, and take extra care when potential conflicts of duties and interests may arise. This is the end of our presentation. If you have any questions, please feel free to let us know.
Thank you so much, Catherine and Karina, for a very insightful presentation. I know I was taking notes. Very many parts of your. I think I'm just wondering. There was one question about whether we'll be sharing slides. And
Yes, we are.
oh, we are. Okay, so we will be sharing slides. And also, I think we also had a comment here from one of the participants who said, "Thank you very much, LC Lawyers, for a comprehensive and informative session."
Thank you.
So yeah, so thank you. So I think because we're on the dot of 2, I'll just we'll not keep everyone from continuing their day, and we wish you well from myself, Joanne, Karina, and Catherine. Thank you so much.
Thank you.
Bye bye.